talking earlier to some folks, and 85% of everybody in Orange County lives in some sort of HOA or common interest development. So it's kind of ubiquitous. But I do get approached by realtors quite often asking some fundamental basic questions about how they can try and streamline the process of buying or selling within an HOA. So I'm going to try and tackle that today as quickly as I can because it is fairly complex, as I'm sure all of you know. But navigating HOAs in California, what do you have to do? Well, number one, you have to accept the fact that HOAs, every single one of them, is a snowflake, all right? They are unique. There is nothing about an individual HOA that can really be prescribed to any other HOA other than the basic rules under California law that they all have to follow, okay? When you buy into an HOA, you're buying into a unique geography, you're buying into a unique set of circumstances, you're buying into a unique community that has its own political dynamics and neighbor disputes. It can go on, all right? So you've got to prepare yourself for the fact that every individual property that you buy or sell is going to, in some way, shape, or another, be unique. I mean, we deal with that all the time, but you have this additional layer with HOAs that you have to just accept and contend with. And just as a disclaimer before I get into the guts of this, I am an attorney. I prefer to call myself a mediator. None of this is legal advice. It is intended for educational purposes only. It does not constitute an attorney-client relationship. Disclaimer, 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 okay? So, every single HOA, and we can go down, I mean, just layers and layers and layers of uniqueness, but fundamentally, you need to be concerned with the fact that every single HOA is going to have a unique set of governing documents, okay? So, you've got, to begin with, a unique set of CC&Rs. You've got a unique set of bylaws. You've got unique sets of policies, procedures, rules, regulations. You've got unique architectural guidelines, okay? You've got unique resident handbooks. These documents, from my perspective, are things that folks should look at in a much more detailed fashion than they usually do. When somebody's buying in an HOA, they're usually focused on two big issues, right? What do I get? What are my common area benefits? And how much do I have to pay for those common area benefits? And that's effectively where the thought process stops. But if the thought process truly stops there and you don't take a deep dive into what those documents require you to do, let alone what they require your HOA to do, you can be in for a very awkward set of circumstances that can make your life miserable if you are a buyer into a new HOA, okay? Even things like defects, okay? Does your HOA have a history of defects? Have they had to undertake some major construction? Was there some fundamental problem when the community was originally developed that is going to continue to cause headaches down the road if it wasn't satisfactorily resolved? Okay, so all HOAs are going to have, like I already said, a unique geography, unique members, a unique system of doing things. They're going to have unique politics, okay? And this is probably the circumstance that causes most people the most headaches, because you have to deal with a board of directors who has been put in charge of actually managing and handling that HOA. When disputes arise, fundamentally, that board of directors is going to be responsible for that. And they're going to be responsible for everything, okay? From the budgets and the financial statements. The reserve funding, that's an extremely hot topic right now, given all of the financial issues that HOAs are coming up against. All of the different assessments. Regular assessments, again, is usually where people's thought process stops. But if you dig a little bit deeper into what's been going on in an HOA, once you make that purchase, you may be dealing with a special assessment. There may be something on the horizon, whether it be litigation or some major construction defect that's going to hit you hard. And I have seen special assessments run over $300,000 for an individual condominium unit. So trust me, it can get really nasty. I mean, you can look at Champlain Towers in Florida and part of the reason that has been given for why there were not actual construction remediations made at that property was the expense of doing them. And the simple fundamental fact that nobody wanted to pay millions of dollars through the HOA to fix the things that they knew were wrong. Amendments and rule changes, right? When you enter into an HOA, when you buy a property in that community, you're agreeing to a contract. You are entering into a contract with your neighbors, with the board. You are locked into that agreement, but that agreement can change. There is a process for amending CC&Rs, usually within the governing documents of an HOA, like when you get down to the ARC guidelines and the policies and procedures, everything beneath the CC&Rs, the board can change those rules. So you have to be prepared for things to be modified. You're not always going to have the same set of rules governing your circumstance for perpetuity. Enforcement policies. If you do something that is even technically or arguably wrong, how does your HOA deal with a violation, right? Fee statements, right? How does your HOA actually deal with sending out different fee statements within your community? Do they send them out regularly? It's a problem that I see over and over again, and I attribute it to a lack of communication. But does your HOA communicate to you exactly what they're doing, why they're doing it, and how they're doing it? All right. Insurance policies. My God, this could be a whole separate topic. The insurance issues just related to fire insurance within Southern California from Orange County inland are extraordinary. You do have HOAs that are flat out losing their insurance policies. They're being issued notices of non-renewal because the premiums are going up to such a level that it is fundamentally impossible for insurance companies to issue new policies. You're seeing it trickle down into the individual homeowner situation at this point, where insurance companies are just flat out saying, we're not going to renew, we're not going to write a new policy, and it's causing, for large communities, a huge problem. Because if you live in an HOA, your association, in all likelihood, has responsibilities for the maintenance and ownership of certain pieces of property, and they have to insure it. It's not owned by individual members. So what does the HOA do if they can't insure that property? They're in quite the pickle, and solving that has become a big problem. Vendor contracts. If you live in a big HOA that has maintenance requirements like gardening, pool maintenance, installation of solar panels is something that I've seen. Your HOA board is going to determine who those contracts are executed with, what companies are actually going to execute the contract and how much they're going to get paid. Seen tons of infighting over whether or not those contracts are quid pro quo. Does the brother of the association property manager happen to run his own landscaping business, and is he getting the contract? You can watch the political fights go on and on and on. That was a long transition. So, all that to say that the only thing that California HOAs, and this goes throughout the state, the only thing that they really have in common are the requirements and restrictions of something called the Davis-Sterling Act. It's over 200 statutes, okay? And you can even go beyond the Davis-Sterling Act into the California Corporations Code. It can get really, really dense. And unfortunately, that's what I'm here for, to help navigate the denseness. But if you want to punish yourself, you can look up Civil Code sections 4000 through 6150. And that will give you a basic rundown of all the different California laws that relate to HOAs, and links to all the different corporations code that aren't included in that link. But assuming you do want to punish yourself, go to davissterling.com. It's a wonderful resource. They've even got a little keyword toggle search bar, so you can basically look up any question that you may have if it relates to an HOA. Now, I'm going to take a step back because honestly, I didn't even really understand what the term common interest development could truly encompass in California. We use the word HOA to describe pretty much everything from a condominium to a planned development. But it is much broader than that under California law. And you've actually got 4 different categories of developments that can be considered what we would all colloquially refer to as an HOA. But under the law, they're referred to as CIDs, common interest developments. That can include a community apartment project, it can include a stock corporation, it can include a condominium project, or a planned development. Out here in Orange County and further inland, you're usually dealing with planned developments, single-family homes that share a common interest, a common area where the members can utilize common amenities. Okay? And that's, like I've said before, what most people focus on. Okay? All this legal mumbo jumbo tends to fly over people's heads because it was written by lawyers who like to make things way more complex than they have to be. Okay? But what matters to most people are those amenities. What do I get? Do I have a community pool? Do I have multiple community pools? Is the HOA going to maintain the grass along the thoroughfare into my, driveway? Fine. That's all good and well. And the restrictions that are placed on these individual units, okay, these individual properties, these separate interests, that is what the homeowner has control over. But nothing else, none of that other common area is really the homeowner's responsibility or control. They get to share in the benefit, but they're not going to have a maintenance obligation, a payment option beyond what is required under the dues that they pay every single month in their HOA. And in fact, it's an often overlooked little snippet of the Davis-Sterling Act. If you don't have common area, you don't live in an HOA. And there are HOAs out there that literally have like a strip of grass that is considered common area just so they can claim that they're a common interest development. As crazy as it sounds. Okay. So who's responsible for managing all this? Right? You've got this massive community that's usually set up. And I've seen HOAs as small as 4 units. I've seen them as big as hundreds of units. I think the largest one I've dealt with recently is over 900. Okay? But somebody has to be responsible for managing all of this under the law. You can't just leave it. You can't dictate it to a property manager exclusively. And that's all done by a board of directors. Okay? Once you form an association, that board of directors is going to fundamentally have control over executing all of the requirements that the HOA is supposed to execute. And that is incredibly broad, folks. I mean, I'll get to another slide in a moment, but I'll preface it by saying HOAs have been considered, even in legal opinions, quasi-governmental entities. They have a tremendous amount of control and discretion over what happens within that community. Okay? So, they are corporations. There is a contractual agreement that you enter into when you join an HOA. But because they're a corporation, they also have to have a board of directors. And that board is going to control the vast majority of what goes on in a particular community. Now, the members of the board, thanks to a recent change in California law a few years ago, do have to be members of the association in 99 out of 100 circumstances. However, okay, because they have increased liability if they are compensated for being on the board of directors, almost every member of a board of directors in an HOA is going to be a volunteer. And this creates a tremendous logjam between the amount of time that someone has to spend dealing with what's going on in 400 to 900 units in their community against the fact that they are not being paid or compensated for any of that time. And that's an understandable degree of frustration. Right? And that's where, very commonly, property managers come in. Right? It's become increasingly common to delegate a lot of these duties and responsibilities to property management firms. And this is one area where you will find some commonality between different HOAs outside of the Davis-Sterling Act. Property managers have been given a tremendous amount of delegation in terms of what they need to do to keep an HOA running. Because frankly, the people who are uncompensated and are board members just don't have the time to do it. Whether it be financial audits, whether it be elections. I mean, the property manager is 9 times out of 10 taking the lead in that to try and alleviate some of the burden that would otherwise fall on the board members. So it's important to maintain good relationships with these property managers, right? particularly when you're dealing with a lot of the big ones, you know, First Service Residential, Power Stone Property Management. You do have property management firms who have grown so big that they have their hands in lots of different cookie jars. And if you maintain good relationships with those different property managers, it will make your life considerably easier as a realtor. And I've already said that, so we'll move on. So getting back to that whole quasi-governmental idea, okay? HOAs hate, and I mean hate, being referred to as quasi-governmental entities. They do not like in any way, shape, or form to be even analogized to this. Because they're not, fundamentally. They are creatures of contract. They are corporations. But the amount of power that they can wield over an individual member's life or the entire community's is considerable, right? They effectively serve within their community every single governmental function that you can possibly think of. And you can be crass, and I often am, and condense it to the executive, the legislative, the judicial. I mean, we can go back to Civics 101. That HOA board is going to have that degree of control over what happens in the community, over how their different CC&Rs are interpreted, over how their bylaws are actually executed, over how violations are handled. That's their little fiefdom, okay? And somebody's got to do it. You can't really blame them for trying to follow the rules to the best of their ability. But it is still incredibly frustrating, I understand, to have a group of 5 to 7 people who are responsible for figuring out how to make your life easier. It turns into a bureaucracy and a logjam very quickly, okay? But they can, like I've already said, go through rulemaking, committee appointments, permitting, rule violations, enforcement, dispute resolution, violation hearings, policy or penalties and liens, maintenance, contracting. All of those are things that an HOA board fundamentally has responsibility over, even if they delegate some of those duties to a property manager, okay? And because they do have certain rules and those 200 plus statutes that they have to follow, such as the Open Meeting Act, which is a watered down version of the Brown Act, if any of you are familiar with that. HOAs are supposed to be transparent. They're supposed to provide all of their members with information that is required by law. It's a frequent subject of dispute when members don't think they're getting a transparent HOA board. It's probably the most common area of dispute. And communication solves all these problems. But not everybody listens to me. They have to keep records. And this is something we'll get into that is, I think, incredibly important for realtors to understand in just a few minutes. Election rules have gotten very, very tight recently. There have been lots of folks who have taken advantage of some of the looser election rules that existed in the past. That's been tightened up. Protected uses of property. If you go to that Davis Sterling website, you will actually see a subsection that is headed Protected Uses of Property. There are certain things that HOAs can't touch. Become a huge subject of dispute over ADUs recently. That's wormed its way into it, okay? They do have corporate requirements. They have to keep meeting minutes. They have to publish agendas. All of these different things that they do, okay, create this wonderful bureaucratic logjam for a bunch of volunteer board members who are not being paid to be there and who probably don't want to be there. But the only reason they are is because nobody else in the community was willing to step up to the plate, okay? You can't blame them for being a little bit frustrated. So, as far as you guys are concerned, the most common topics of inquiry that I get from realtors are how to get a hold of those wonderful sets of documents that are required right before the close of escrow, right? Why do I have to pay so much for them? Why do they matter? How do I get them with this ridiculous 10-day window of time that puts me in a bind, and I can't ask for an accounting, and I can't ask for invoicing, and I'm just forced to go ahead and send my clients a bill for $600 to $1,000 for documents that I know are maintained online, okay? So this is where it really applies to you, okay? So these are similar to, if you've ever had to do it, a public records request. HOAs have to maintain certain sets of documents for a certain number of years. Think of it as tax forms if you want to, okay? But it goes way beyond just the financial accountings of an HOA. Under Civil Code 4525, and again, you can look this up, and you probably have seen it in a form that I'll show you in a minute, the HOA has to provide certain sets of documents upon request to a prospective purchaser. The seller is also kind of tied up in this. The way that the language is written is that the seller has to make that transfer, but usually they can cover themselves if they have the HOA provide them all the documents that have been requested. Okay. But if you go to Civil Code 4528, that form that you're also familiar with is actually in the code. There's actually a copy of this sucker in the law saying all of the different checklist items that need to be disclosed. And if they exist in the HOA, then they need to be provided to a prospective seller, or prospective purchaser, more importantly. Okay.
Can you go back to the Civil Code 4528?
Sure. One more. There you go. Sure. Everybody's seen that form before, I'm assuming? Yeah. Okay, so getting a hold of these documents, I understand it's incredibly frustrating. Now, for some reason, and this is probably my greatest source of concern, sellers don't have this information readily at hand. Most people, once they buy into an HOA, they bury their heads in the sand, they pay their dues, and they move on with their lives. And they never have any reason to complain about it. But if you don't know what is going on in your HOA, God help you if you find some sort of dispute or a fight that you want to pick with your HOA board. You need to know what your responsibilities are and what the HOA's responsibilities are, where those lines are drawn. In a condominium association, if you are the owner of a unit, nice little, basically drywall interior of a unit, and your HOA has maintenance responsibility for all of the structure that goes beyond your unit, I can guarantee you if there's a water leak, some sort of an issue, you can be in for a fight over whose responsibility that is, because nobody wants to pay for it, okay? So know where your responsibilities end, where the HOA's responsibilities begin. But there are regulations, I'm sure you're all familiar with, that require the HOA to provide these documents so that a prospective purchaser can have an understanding of what they're buying into. What are they agreeing to? What are they contracting to? And they do have to provide these. They can't withhold them. If anybody gives you grief, there is an obligation for them to produce it. But they can, of course, try and charge you for them. And this is where planning and preparation makes all the difference, okay? So, associations can charge a reasonable fee for providing these documents. The ultimate question is, what is a reasonable fee, right? Okay, so I think there is a fair argument to be had over whether or not a reasonable fee should be charged if an HOA or a property manager maintains all these documents on a published electronic website, which is becoming the common course of business. So how in the world do we get down to an individual invoice or accounting of how much money can be ascribed to producing these documents if all you had to do was send me a web link, all right? This is the thing that usually gets people going. So, those costs under the law are supposed to be based on the association's actual cost for producing the documents. So if you have the time, if you have the opportunity to ask for an invoice or an accounting of what the actual costs are and how those can be attributed to the HOA or to a property manager, how much time was physically spent preparing the electronic copy of the email link, then there may be a battle that you can have over that type of subject. But if you run up against the 11th hour and you're within 10 days of closing and you don't have the time to sit there and pick that fight, it's not a fight that you can have. You've got more pressing issues, okay? But there's nothing to stop you from requesting an invoice. There's nothing to stop you from making a phone call or sending an email, particularly if you've developed those good relationships with property managers who, more and more commonly, are the ones who are responsible for maintaining those association documents. Hey, I have a potential sale. You don't even have to go that far. I'd like to get a hold of association records. It doesn't stop you from having the conversation. But when you get up to the 11th hour, again, it's obviously not a conversation you want to have. And since they're increasingly in electronic format, I think it's a worthwhile conversation to have.
The right escrow company is a big key. They'll help you.
Right. Yeah, no, there are resources out there. You've just got a plan. That's what it really comes down to. But more than anything else, why I think planning is essential is because when you're selling to someone who's buying into an HOA, as I've said before and will continue to say till I'm blue in the face, these documents matter. They are going to govern the way that their lives in their home are allowed to operate as long as they own that piece of property. So if you're getting documents to a prospective purchaser at the 11th hour, I can almost guarantee you they're not going to read them. They're not going to take the time to say, wait a minute, this is kind of weird. What about this little bit here that says that I have rental restrictions on my property? What about this little bit here where the HOA is trying to pass a rule prohibiting ADUs? What about this little bit over here where it says that the HOA is involved in litigation? If you don't look at the stuff, you'll never know what's actually going on. And that goes for every single bit of the governing documents, the bylaws, the operating rules, all of the different rental restrictions, the budgets, the financial statements. Is your HOA in good financial health? Are you buying into a community that is going to require you to pay a special assessment in the short term? All of the different assessment fees should be in there. The fee statement of the association, the defects and violations. Does the piece of property that you're purchasing have a violation that's hanging around it? I mean, God forbid there's a lien on that piece of property. That would be an easy thing to uncover in your line of business. But you're not always going to find a violation notice trickling around, okay, if the HOA has not escalated it to the point where it's a recordable document. And God forbid insurance. I mean, the bane of everyone's existence today. Knowing what you're getting into is key. And I'll skip through a lot of these. I'm sure you've all heard more than enough about CC&Rs by people other than me. But I mean, that's the big one. The covenants, conditions, and restrictions, that's what is really binding you and defining the duties and obligations of everybody in that community. The crazy thing, and why I think it's important to look at all the documents, is that most of the time, particularly if it's a new development, the CC&Rs are going to give authority for the board to make rule changes, to appoint committees, to do things that are not explicitly stated within the CC&Rs. Okay. The bylaws are going to control your association's governance. I mean, elections, rule changes, all that good stuff. Your operating rules, you can run afoul of them. You can be assessed penalties and violations if you're playing basketball at 6 a.m. or your kids are. It happens. I know it seems preposterous, but yes, people have gotten $500 fines just as a threat to change the color of their Ring doorbell. What do you call it? Bezel. I mean, we've all seen it one way or another. So be aware of it. I mean, the ARC guidelines are the thing that probably causes the most issue that actually ends up in court. If you want to make a modification to your property, be prepared to jump through some hoops. You're not just going to be dealing with permitting from a city, you're going to be dealing with permitting from your HOA. Money, always a good thing to know. What is the financial health of my HOA? It's all contained in those disclosures. What am I running up against? What do I have to worry about? Defects. Has there been anything substantial? Do I have a massive special assessment coming my way? That could be revealed if you look at all those disclosures. And the board meeting minutes, for the love of God, I wish that that stupid document under 4528 did not make it an option, but it is. A prospective purchaser can request the last 12 months of board meeting minutes to find out exactly what has been transpiring What's the scuttlebutt? What's going on in the community? But you have to request them. And if you don't request them explicitly, the board doesn't have to provide them, or the HOA doesn't have to provide them. But that can make all the difference in the world in knowing what the recent health of your HOA is looking like and how that could affect you in the future. So, some novel ideas for potentially eliminating the craziness that is associated with trying to get those documents at the 11th hour. There is a separate section of the Davis-Sterling Act which allows any member of an HOA to request all of these documents for no reason whatsoever. You can just request them because you're a member. If you have a prospective seller in a community, they can make that request. There's still a timeline. The HOA still has to provide you with all of the documents from the past year within 10 business days. Right? That will put those documents in the seller's hands and allow you to put those documents in the buyer's hands. Now, does that eliminate the benefit of going through and getting that wonderful little checklist? No. Having the HOA check all those boxes and say these have all been produced, that's a great thing to have. But does that give you an opportunity to request an invoice and accounting if they demand that there should be some fees tied to that production of documents? Absolutely it does. Does it give the prospective purchaser time to review those documents before they actually close? Absolutely it does. You don't have to be hamstrung by 4525 and 4528. This can all be done up front, and the planning and preparation associated with that, I think, pays dividends. But you're doing the selling, so. Like I said, there are deadlines. Documents from the past year, 10 business days. Documents from the past, or the previous 2 years, so 3 years total, 30 days, okay? They can be copied at the association's place of business. That typically tends to be a property management company in this day and age, okay? Or you can agree to have them copied at a mutually agreed to location. It can be anywhere. You can go down to Kinko's if you really need to, okay? Or you can request that copies be delivered. And because almost everything is being maintained in digital format these days, it's a pretty short and simple process. But you've got to talk to the seller. They're the ones who have the authority to ask for this sort of stuff. HOAs have to produce these documents under 5200 or 4525. They don't get a pass around it. And when they don't produce these documents, even if it has nothing to do with a sale, I have seen lots of people who want to go to small claims court to enforce this because there is a civil penalty of $500 that says if the HOA doesn't produce those documents within the prescribed time frames, courts can enforce a civil penalty. And anything under 10 grand goes to small claims court, thank God. But if a person really has a fire in their belly and wants to prove that that document disclosure deadline was not met, they do have an enforcement remedy. And so do you in theory. I mean, you're not the one who's obligated to get it, but it is information to pass along. And why does all of this matter ultimately? Because there are way too many HOA lawsuits. In Orange County alone, and I promise for the benefit of the folks hosting this, I will get numbers for San Bernardino, Riverside, San Diego, and Los Angeles. But in Orange County alone in 2022, there were over 350 lawsuits filed related to HOAs. It goes on way too much, and it is expensive, and it is miserable, and it is unnecessary. And I'll give you my favorite example. I will never stop talking about this case because it still just gets me lit every single time. Okay? So, court battles without a good understanding of the governing documents, okay? Even with the good understanding of the governing documents. One Ford Road v. Johnson. Look it up. You can actually pull it up right online and you can read all the appellate decisions about it. It's very entertaining. Starts off fundamentally with a homeowner who wants to do some renovations. Does what she's supposed to, applies to the HOA, gets their authorization, okay? Pays a $5,000 deposit because that's what the HOA required. Now, things don't go so well because after she's completed the project, the HOA wants to send an inspector through in order to verify that she actually did what she said she was going to do. Okay? Now, there's a bit of a dispute that arises because the inspector that the HOA sends out for the first time is a private architect. It's not a board member, it's not a committee member, it's a privately retained architect. So the homeowner, understandably confused, says, what's going on? Why do you have this private architect coming to my house? And that whole conversation takes so long that by the time everybody agrees that this architect is going to come through and do an inspection, the timelines prescribed in the CC&Rs have elapsed. And now the HOA says, you are in violation, homeowner, because you did not allow an inspection within 30 days. The homeowner says, no, HOA, you are in violation because you did not conduct an inspection within 30 days. 4 years later, a court trial and an appeal all goes through having the HOA win at trial and be awarded $150,000 plus in attorney's fees. The homeowners appeal, and they win on appeal, and the appeals court says, no, the trial court was wrong. The homeowners at that point have spent over $300,000 on attorneys, and because they went on appeal, they get to ask for their attorney's fees back now, but the court only awards them about 200 grand. So the renovation project out of pocket for those homeowners who ultimately prevailed and said they were right over, I mean, literal nothingness. It came down, and I will highlight this for you, to language that said that the homeowners did not refuse access for inspection within the meaning of CC&Rs. That was the fundamental issue that everybody fought for 4 years and spent $500,000 on. Did the homeowners refuse access within the meaning of the CC&Rs? If that case can go to trial, I can guarantee you, not understanding your governing documents can send you to trial much more easily. Both those parties spent easily $500,000 on attorneys fighting over that stupid little phrase. Did they refuse access? Okay? And the HOA took their hardline position, the homeowners took their hardline position. The HOA said, we're fining you $500 and we're not refunding your deposit for your modifications. The homeowner said, to heck with you, and they end up in court. And 4 years later, that's the decision. Could it have gone the other way? Absolutely. The court could have found for the HOA again, and then the homeowners are absolutely out. It's that much of a roll of the dice. Don't allow it. And with that horrible set of circumstances, I'll open up the floor to questions.
Remember to repeat the question.
Yes, sorry, and I won't walk away from the camera. Duh.
Okay, so just to be clear,
Yeah.
the homeowners can actually request a set of documents.
Correct.
The complete set, correct? Everything that one needs to close escrow.
So if you look under Civil Code Section 5200, there's actually a one-sentence little line that says, any documents required to be disclosed under Section 4525 can also be requested under Civil Code 5200.
Okay, so then the homeowner knows that they are going to sell the property, they can request the documents way before.
Yeah, whenever they want. They could request the documents 10 years ago, 2 months ago, whenever they want. They always have the ability to request those documents. They're required to be maintained, and they can make that request at any time for whatever reason. It does catch property owners and HOAs off guard. They're not used to doing this unless it's, you know, I get to charge $600 to $1,200 to produce these things because somebody's selling a piece of property. But it's allowable.
And they only need to prove that they spent X amount of time and it will charge you X amount of money because of whatever they
So
spent.
again, the question comes down to what is a reasonable fee?
Right.
And the question was, sorry, I'm not repeating the questions. So the question was, they're only allowed to charge you the amount of time and money that they spent preparing those documents. So the way that the code is written, they can charge you a reasonable fee for providing those documents. But they have to tie that to the actual activities involved in providing them. So my fundamental question, whenever I'm given this question, is, what did you do? Did you click a mouse? Did you copy a link? Did you send an email? And if that is the case, why in the world am I being charged $600 to $1,200? If you do this in advance, you give yourself the opportunity to at least ask that question.
Okay. do you have like a portal that people go to? Like we use a lot of the portals
Yeah,
to get.
no, that's very common these days. The question was, do they have portals? And yes, lots of the big property managers in particular literally have a web portal that has all this stuff. They have the last 12 months of meeting minutes, the agendas, the committee meetings. All that stuff is maintained in digital format so that they avoid those wonderful little civil penalties. No, it's constantly here for your availability, Mr. or Mrs. Homeowner. It's always something that you can get access to. Yeah.
The sellers will go to this portal or send an email to the management company. How is the process?
So I would still, like if I was in your position, and you guys do whatever the heck you want, consult with your own individual in-house counsel, but I would still love to have that little checklist. I would not want to avoid the checklist so that I then had to justify how I got it and whether or not I had any responsibility or due diligence required in order to make sure that those documents were accurate. I wouldn't do that. But at the same time, if everything is published, if everything is already available, why in the world are these fees attached to it? That's the fundamental concern that I get over and over again.
So you get the documents, and you don't close for another couple of weeks. What's floundering out there in the universe about things that aren't quite done yet? They haven't, gone down yet. So where do you have to get the amendment to that document from the time you receive them to the time you close? That something might have taken. They have to.
Absolutely.
Okay.
Yep. So part of the sort of strategy I'm saying I think is feasible is if you get all those documents, and ideally, if the HOA doesn't charge the seller for those documents up front, then the only question you have to ask is, okay, here's my 4528 form. Anything changed? Because we got these documents a month ago. So can you please just check the boxes? And if it takes you $600 an hour to check the boxes, then there's a fundamental problem. So,
But even if it's still, it hasn't gone down, but it's out there. So the new buyer moves in, and 2 weeks later, all of a sudden, so is there a pending status, that stuff that you get that's not been enacted already, that's included in all that?
and this is why it's so important, I think, to check what's going on in the HOA. Because they are a corporate entity, they do have to keep meeting minutes. They do have to have new agenda items. If you don't check that box requesting the last 12 months of meeting minutes, there may be an unpleasant surprise coming down the pipe. So getting those meeting minutes is fundamental to knowing what's going on right now and what could be happening a month from now.
Thank you.
Go ahead. Sorry.
Two questions in regards to board of directors. What constitutes being a member of the association?
So the question was, what constitutes being a member of an association? So it's actually defined under Civil Code 4000 through 6150. But you have to be an owner of a separate interest under most associations, CC&Rs, in order to be a member. If you're a renter, okay, you're not going to have membership status. Do you get to enjoy the amenities of the community? Sure. But you as the owner of the property, whoever is renting that property out, is still a member of the association and is going to have the duties and obligations of a member of the association.
Other question, what if the board, namely the president, depletes reserves? This is coming from a client of mine, so you're left with no reserves, all for community improvements.
Right.
What recourse do the homeowners have?
So the question is, what happens if the board depletes reserves? And it does happen because a board is supposed to go ahead and plan for the future, for lack of a better term. Penny saved, penny earned, whatever cliche you want to bring into it. But occasionally you will have a circumstance where a major improvement, a lawsuit, there is something of tremendous expense that is depleting the reserves. And you still have this little community, maybe even not little in this day and age, because there are some places down in South County that are thousands and thousands of units, that is now capable of saying, wait a minute, Mr. or Mrs. Director, Madam President, Mr. President, what in the heck is going on? And again, it's why communication is so important. Because if the community doesn't understand why those expenditures were necessary, that's when you get the scuttlebutt underground grumbling that can lead to things like recalls, requests for new election, special meetings. There's all kinds of different things that can be done but it all has to be done within the confines of the individual rules of the HOA. So it very much depends on what those CC&Rs say, what those bylaws say. All that stuff will govern what recourse a person may or may not have within their community. Back.
So I have a question about if a seller requests documents privately outside of an escrow, is there an increased risk to the seller for liability if either something's left out, if something is stale, if there's something new that happens as a result of them requesting it versus paying the $600 or $1,200 or whatever it is to request them through the proper channels?
So the question was, is there an increased risk to a seller who gets documents and doesn't go through the 4525 or 4528 requirements of that little checklist? And that's exactly why I suggest going through that checklist. What benefit you're offering to the seller and the buyer by at least suggesting getting those documents in advance is, number one, you're testing the waters as to what the cost is for these documents, and you're affording yourself the opportunity to ask those fundamental questions about how much did it actually cost to prepare these. And number two, you are giving the prospective buyer an upfront opportunity to look at what they're buying into. That certainly helps everybody feel safe and secure. Number three, you still can make the request under 4525 and 4528. So when you get down to the nitty gritty, you can still say, hey, here's the checklist HOA. I need to make sure all these documents are good. And if they send you a bill for $600 to $1,200, then you can again ask the question of, wait a minute, we just got these documents a month ago. Has anything really changed? I mean, is the web link now more expensive than it was? You know. I don't know where to go. We'll go here.
Two quick questions. One is gaining access to HOA meetings if you're not living in that community. Years ago, I had to get into a board meeting because there were 4 lawsuits in civil in Santa Ana against the HOA because I noticed the 4x4s were all painted different colors, and they had leaking problems and flooding and irrigation problems. And I went to the HOA meeting. They wouldn't let me in until I got at the time I had a lease signed with the owner. She was elderly, so just make me a tenant so I can. And they said there's no litigation, and I produced documents which are public, and it was so difficult to be able to have a voice in there. She was elderly, so she couldn't. So that's the first one. The second one is in terms of, you mentioned HOA directors and personal liability. There is insurance, isn't there? Because I know I had one client that had to sue in small claims court because they were charged Mission Viejo. They had an assessment for $13,000, or you had a choice of paying $177 a month. I won't say which one it is. People remember. And this, unfortunately, they didn't have realtors involved when he bought it from his landlord, so he had to. He was being charged both. He used a escrow company, not Generations. And he was being charged both, and they wouldn't relieve him of the second payment.
I don't know if I can condense that into a repeated statement, but I will say this. When you are dealing with individual and especially nuanced issues within an HOA, it's why I harp so much on knowing what the governing documents say and what rights and responsibilities they give you. You can go to the Davis-Sterling Act as a primer about minimum obligations, but if you really want to know what you can and can't do in your community, the CC&Rs are going to dictate it. The governing documents are going to be your guide for how to deal with all those disputes and problems, even down to what are the procedures for dealing with a dispute. There's actually a whole body of the Davis-Sterling Act, and almost all HOA governing documents have been updated now to say, if you have a dispute, here is how you go about addressing it. And there's 2 fundamental mechanisms to do that. But that would take me a whole other presentation. Sorry.
I have a quick question. So I know there in Mission Viejo, once you purchase a home, it already includes the Lake Association and then the Mission Viejo Swim and Racket Club. So what would you suggest for the new homeowner to opt out of it? They usually say it's forever. Is it really forever?
It very much depends. And getting in, the question was, is there a mechanism to opt out of certain amenities within an association. And I think it fundamentally comes down to what has become very typical in the larger developments in Orange County, where you have a master association and then sub-associations that govern individual developments, condominiums. Mission Viejo is kind of notorious for this, probably the model for it. Getting into the nitty-gritty of that, sorry, I mean, give me a call afterward.
Question, how long, I know you said it's all volunteers mostly.
Yeah.
How long can one person actually stay on a board?
So the question was, how long can a person stay on the board? Again, the answer is depends on the CC&Rs, depends on the bylaws, depends on the rules in the individual community. There are limits that can be placed on it, and they're very common limits, but there's nothing that restricts, like California-wide.
Where would we find that? Is it under the bylaws? Is it under?
So you've got to start with the CC&Rs for any community. That's going to be your fundamental baseline set of governing documents. But usually within the CC&Rs, you will see something to the effect of this section of the CC&Rs allows the board to promulgate rules and bylaws for the maintenance and governance of the association. If you see something like that, go to the bylaws. Like, what are the actual election rules? What are the term limits? Who can not run? Who can run? All those sorts of things should be in there.
Okay, I'll check that out. But I also have a question. If they send out violation letters to people in the community for something, should they or do they need to attach where in the CC&Rs that violation offsets?
Fundamental issue with communication. This is one of the many areas where people are just blindsided.
Right.
Like, I'm in violation of what?
Right.
And I've seen violation notices as vague as just saying nuisance with no further explanation. But fundamentally, as frustrating as it is, finding out what's going on rather than popping your top and saying this is outrageous is a far more productive use of your time. If you want to go ahead and get angry at them, you will probably end up in court. They will dig in their heels and you will dig in yours, and you can have a wonderful little 4-year court battle. But just asking, okay, got a letter, what in the world's going on, will usually help you figure out what the heck is happening. But yeah, it happens all the time. Anybody else? No, more in the back.
Why do some associations elect to rewrite the CC&Rs as opposed to amend them?
It just depends on what the board of. So the question was, why do some associations elect to rewrite the CC&Rs instead of just amend them? And that all comes down to who's in charge of the association. I mean, the people who are the members of the board of directors get to make that decision, and they can make that decision for any number of different reasons. One of the biggest problems that you probably see is associations who have CC&Rs that were written in the 70s, and now they're 50 years old, and they need to be updated because there have been about 200 plus additions to the law, and it just makes more sense to rewrite the suckers. But it depends on who your association board members are and what decisions they're operating under. Yeah. Anybody else who hasn't asked a question? Okay. Okay. Sorry, ma'am.
As a agent, district agent, or a selling agent.
Sorry.
As
Here,
a list-
can you hand that microphone to her?
Sure. As a listing agent, we always do our due diligence. And in that due diligence, we sit down with the seller and get the HOA and all that. As an attorney, do you have a checklist that I always read my CCR, I always read HO, I do my due diligence before even so I know more about the HOA than even the seller does, and I work with the seller. So you have for us, can you give us a checklist that we should be looking into it, even though you need 3-4 HOA, CCRs and bylaws and all that to get to know what you're looking. But do you, as an attorney, will advise us as a new agents and the old agents that this is a checklist you should look in the CC&Rs, bylaws, and mostly it is a budget, mostly it is what are the main rules and regulations, because going into the details, we don't need to do that. That is attorneys. But as an agent, that is what we need to know from you. What is the checklist? 10 checklists that look into this, look at the budget, look at the lawsuits, look at this, and then ask those questions to the seller, because seller mostly has a very good relationship with HOA. So the common sense, if you can, all of us can use that and do our due diligence up front. I think we can avoid a lot of lawsuits.
Do you have like a guide?
All right, so trying to reduce that question down, I think it was, is there a checklist of things that we should be looking for in governing documents that we can discuss with sellers? I will say again, I'm not here to provide legal advice, no attorney-client relationship, and I will refrain from getting into specifics for that reason. However, when you're going through and looking at that checklist on 4528, that is your first sort of indication of all the different things that you should be looking for. And that checklist is great because it provides you with an understanding of what documents actually exist within the HOA. So you can go through, and maybe the HOA doesn't have a resident handbook. Maybe they don't have explicit rules and regulations or policies and procedures. If they don't exist, that's one less thing for you to worry about. But the list of different things that you could be or should be concerned about is so voluminous. I would be sweating through 3 suits talking about them all. I mean, whatever you can possibly think of that could affect your ability to live in your home is something that you could be concerned about. I mean, whether it be a neighbor, whether it be your desire to, heck, redo the interior of your property. I mean, I've seen disputes that happen over folks who are making modifications to their backyard and say, hey, under the CC&Rs, all that you have control over is what's visible from the street. And HOAs say, we don't care. You're making modifications that are visible to your neighbors, and we're enforcing it. So, I mean, pick whatever you want. I'll put it this way. My wife practices family law. And if there are 2 areas of life where you can watch people fight like caged rats, go after their home or go after their children. So whatever you can think of that could be the source of a fight, that's what you should be looking for. It could be anything, literally anything. Yeah. Right. Well, remember that if you are giving what could be construed as legal advice as a realtor, you're falling into a really heavy trap. And I'll give you a stupid example, but it's worthwhile, right? Condominium owner sells their condominium, and during the whole sale process, there's confusion over the assigned parking space. The buyer, about a month after closing, says, what the hell, I'm getting violation from the HOA because I'm parking in the wrong spot? No, this is where the realtor told me I needed to park, okay? And now the HOA is telling me I have to literally park in front of the trash dumpster. What the heck's going on here, okay? That puts you in a very sticky situation. Another benefit of getting those documents early, even if they're not complete, is you can say, look, here they are. Here is the body of information that we have at our disposal right now. If you want to talk about the nitty-gritty of this and your rights and responsibilities, give an attorney a call. You do not want to put yourself in that position.
Regarding the HOA changes the CC&Rs to insurance issues these days, can you talk to us a little bit about that process? How lengthy it could be, or
the question was, can you talk to us about the process for amending CC&Rs due to all of the insurance craziness that's going on right now? It can go on for years. That's the short answer. I mean, so amending CC&Rs in theory has been streamlined, but you still have to get a quorum. You still have to have a vote that meets the quorum. You still have to get the members of your community to agree to those modifications. If you can't make that happen, and it's an issue that is fundamental enough to the health of the association, in theory, there's a process that you can use to make a petition to the Superior Court demanding that the court basically modify the CC&Rs. But even that does not always go the way folks want it to. You will usually get some members of the community who say, no, I don't have enough information and this seems wackadoo, so we're going to fight the petition. And then you have a months-long court battle over should the CC&Rs be amended or not. And that can spiral out of control into we don't want this board anymore, they're going crazy, into we think that they're breaching their fiduciary duties and we want to pursue a lawsuit and we want to name them as individual members. I mean, the list, the parade of horribles is endless. So.
What if we are dealing with normal, wonderful, perfect people? How?
No such thing. No such thing. Yeah.
But could be 6 months?
Could be.
It could be.
Could be.
It could be if people are civilized.
Sure. Yeah. We all have our own individual biases and prejudices and priorities. And all you have to do, I mean, heck, you could probably pull up examples on YouTube of folks who have the unfortunate circumstance of living next to an HOA board member. And miraculously, it seems like every single iota of the rules get applied heavily to them because they literally have a watchdog living next door to them. But if you happen to just live next to neighbors who like to play ostrich and keep their heads in the sand, you'll probably never hear a peep.
You should have to disclose that.
So.
That the president lives next to
Right.
the board.
It happens. It happens.
Are board members allowed to do work for the community?
Are they allowed to do work?
Like a contractor or somebody like that?
They're putting themselves in a sticky situation if they do.
I thought.
Yeah. I mean, you run into, just like any other political entity or corporation, if you're acting for your individual benefit or you're acting on an issue that could be perceived as providing you an individual benefit, you're going to run into conflict of interest issues and questions. Yeah.
She has one right here.
Yes.
I don't know if this question has been asked before, but I'm curious. Is there any law that you know of that can dissolve an HOA?
In theory, it can happen. Yes, there's a mechanism for it.
There is.
Uh-huh. Yeah.
What actions
You-
sellers have to not
You're
sellers,
looking,
homeowners.
depending on exactly what your governing documents say, you're at least looking at a very protracted exit from an HOA environment.
Office that can do that.
I can probably refer you to some folks who would be willing to take on that sort of assessment. Because with any legal problem, the first question I ultimately ask is risk versus reward. And I know not all lawyers do this, but okay, you have a fight, you want to pick a fight, or you think you've been aggrieved and you need to defend yourself. Great. What is the cost of that in terms of time, money, emotional stress, absence from work? Because congratulations, those are just the big picture items you will be giving up if you want to file a lawsuit. So if you want to go through the process of trying to unwind an HOA, I've never tried to do it, and I will never try and do that. I guarantee you that will be a lot of work. So.
But it can be done, right?
There is, in theory, mechanisms for it that I have seen, but I am not going to take on that sucker. No. I like to help people stay out of court if it's at all possible. So that's a heavy lift. Yeah.
How much are we looking at?
Oh, I have no idea.
A billion.
I'm just asking.
It's like every other question that I've answered here that tried to get down to the nitty-gritty. I could not even begin to approach giving you a specific because I have no idea what that community looks like, what their documents look like. Yeah. I mean, you can use the One Ford Road. You can fight over one single word in your CC&Rs and spend $500,000 if that gives you an indication.
I looked at it
Yeah.
already. I looked at the litigation. That's interesting.
Oh yeah, and that's just one of many. Yeah. Sorry.
with other plans, but in regards to,
Well, I think she might have been hot as well, so I just don't want to overdo it.
Right now they shouldn't be, but I guarantee you they're trying. People are fighting like crazy over HOAs trying to restrict that. The way that they wrote the ADA or ADU legislation, it at least suggests strongly that HOAs can't provide any additional restriction on it. Those ADU guidelines say, hey, if you meet all the other requirements for permitting, you're good to go, because we need housing in California. That's the intent behind it. But it has not stopped HOAs from fighting it tooth and nail. And we'll see that unravel in the courts as to exactly how much authority they can exert. Yeah. Oh, another one in the back. Sorry, what was the question?
If the CCNRs and the condo plan have conflicting information, which document prevails?
So the question was, if the CCNRs and the condominium plan have conflicting information, which document prevails? The CCNRs are going to be your preeminent authority. Those covenant conditions and restrictions are the ones that are going to be at the tip top. Now, without knowing exactly what's in those CCNRs, there may be another wonderful little clause that says the board or whatever authority drafted those CCNRs or restated them can promulgate a condominium plan to further whatever else is in these CCNRs. So again, it very much depends on exactly what they say. I wish there was a clear-cut answer to this stuff, but in Orange County alone, you've got nearly 5,000 homeowners associations, common interest developments, and every single one of them is going to be a little bit different. So, anything else? Good, because I'm sweating through at least one suit.